Preparing and filing a response, or answer, to a petition. A response or answer to a petition is a formal, written statement filed by the respondent, the person responding to a lawsuit, in response to claims made in the initial petition. This document allows the respondent to agree with, deny, or clarify each point in the petition and to state any defenses or counterclaims. The response or answer must be carefully prepared to address each allegation or request in the petition. Step 1. Understand the purpose of a response or answer to a petition. The response or answer provides an opportunity for the respondent to formally respond to each claim made in the petition, agree with or contest specific statements, allegations, or requests in the petition. Present any defenses or counterclaims. Ensure their perspective is part of the court record before a hearing or other legal proceedings. Responding in a timely and detailed manner is crucial, as failure to file an answer may result in a default judgment, where the court may grant the requests in the petition without considering the respondent's side. Step 2. Gather required information and documentation. Before drafting the answer, ensure you have a copy of the petition, the petition filed by the petitioner, so you can respond to each point accurately. Court and case. Information: court name, case number, and names of both parties. Supporting documents: any documents, evidence, that can support your response, defenses, or counterclaims. Legal advice, if necessary. Consulting an attorney can be beneficial, especially if you wish to file counterclaims or assert specific defenses. Step 3. Draft the response or answer to petition. Follow this structured format to prepare the response or answer. Court heading: include the court's name, case number, and names of both parties. Example: in the Family Circuit Court of County. State: list the full names of the petitioner and respondent. Title and opening statement: title the document as Response or Answer to Petition, and begin with a formal statement. Example: comes now the respondent, your full name, and submits this response to the petition filed by the petitioner. Petitioner's full name. In response to the allegations, the respondent states as follows: admit, deny, or state lacks sufficient knowledge. Address each paragraph in the petition individually. For each claim or allegation, state whether you admit, agree that the statement in the petition is accurate. Deny, disagree with the statement, lack sufficient knowledge. State that you do not have enough information to confirm or deny the claim. Example for responding to an allegation. 1. Respondent admits the allegations contained in paragraph 1 of the petition. 2. Respondent denies the allegations contained in paragraph 2 of the petition. 3. Respondent lacks sufficient knowledge to admit or deny the allegations contained in paragraph 3 of the petition, and therefore denies the same. Defenses. List any legal defenses you intend to use. Some common defenses include lack of jurisdiction. The court does not have authority over the respondent or case. Failure to state a claim. The petition does not provide adequate legal grounds for relief. Statute of limitations. The time limit for filing the petition has expired. Other defenses include any specific legal defenses that may be applicable in your case. Counterclaims, if applicable. If you have your own claims against the petitioner, state them in this section. Identify each counterclaim clearly and explain what relief you are seeking, e.g. custody, property division, or financial relief. Example: Counterclaim 1. Respondent requests joint legal custody of the minor child, Ren, based on the best interest of the child, Ren. Prayer for relief. Summarize what you are asking the court to do in response to the petition. Example: Wherefore, the respondent respectfully requests that this court deny the relief requested by the petitioner. Grant the respondent's counterclaims as outlined above. Award any other relief that the court deems just and proper. Signature and contact information. Sign the response and include your contact information. Full name, address, phone number, and email address. Date of signing. Verification, if required. In some cases, the court may require a verification statement at the end of the response. Example: I, your full name, declare under penalty of perjury that the information in this response is true and correct to the best of my knowledge and belief. Notarization, if required. If notarization is required, sign the document in the presence of a notary public. Step 4. File the response with the court file with the clerk of court. Submit the completed response to the court clerk in the county where the petition was filed. Check for filing fees. Some courts may require a filing fee for the response. If you cannot afford it, inquire about a fee waiver. Retain copies. Make copies of the filed response for your records and for service on the petitioner. Step 5. Serve the response on the petitioner. After filing, you must serve a copy of the response on the petitioner, or their attorney if represented. Proper service methods include personal delivery. Hand deliver a copy to the petitioner or their attorney. Certified mail. Send via certified mail with a return receipt to confirm delivery. Court-approved electronic service. In some jurisdictions, service may be allowed via email or an e-filing system. Confirm service by filing proof of service with the court as required by court rules.